And you still have the right to confront witnesses against you, news. A California court has ruled that police body cam footage, for all of its glory, doesn't necessarily replace your right to confront witnesses. Because, you have the right to talk to the witnesses and actually confront them in court. So the camera may show a lot of things. But to the extent that those things are what a witness is reporting or whatever, well, you have a right to confront your witnesses. So, yeah, the body cam footage, although it might accurately reflect what the witness said, you have a right to confront your witnesses. So the camera alone won't do. Amazing. Let's learn a little bit more about this. More California police are deploying body cameras, and that is a good thing. A new court ruling restricts how prosecutors can use the footage at trial because, you might have a right to confront witnesses. In a case when a woman refused to testify against a man accused of assaulting her, the judge used the accusation she made the night of the incidents that were recorded on a police body camera. So this woman says, "This guy assaulted me." Her reporting this was captured by the body camera. The police are taking the report. Here's the woman. She's making the accusation. "This guy assaulted me." This week, the California Supreme Court ruled unanimously that the judge erred in using the body cam footage to stand in for the woman's testimony because it denied the ability to confront it, right? This is the problem. This is a woman who says, "He assaulted me." So the camera isn't capturing something that's happening in real time. It's capturing something that someone is reporting on. A statement that is being made outside of court, offered for the truth of the matter asserted. And you have a right to confront that witness. So the trial court's like, hey, this woman's report was captured by the body cam, so she doesn't need to testify. And the guy's like, she says that I assaulted her. I have the right to, cross-examine her and confront her in court, as one does. And trial court's like, no, you don't. And the California Supreme Court's like, you totally do, because of course you do. The Supreme Court writing, we emphasize that a defendant's due process right to confront a testimonial witness against him is not absolute, which, fair enough, because if the witness says, the guy stabbed the woman and the woman's body is over there, and the police go and they find the woman's stabbed body, then, well, the witness is kind of neither here nor there, right? I found a body with the stabbing. It's over that way. And the police go and they find the body. You don't have a right to confront that witness because, well, we found the body, right? The witness's report is no longer material. But in this particular case, the woman's report is extremely material because it isn't, here is where the body is located. The guy assaulted me. So there is no independent evidence for the police to go find. The woman's testimony is the evidence. So, offer it in court. The Supreme Court writing, what cannot be done, however, is reducing the analysis to a single determination that hinges solely on whether a statement qualifies as spontaneous. So, yeah, there's like, oh, this is a hearsay exception because this is an excited utterance. Well, it might be a hearsay exception, maybe, although that's even debatable, to be quite honest. But even if it is a hearsay exception, still the right of confrontation. It's like, oh, it's an excited utterance, so it's reliable. Yeah, but it's a criminal accusation, so I have the right to confront that. The ruling comes as body cameras have been made more common in California police departments, most recently this year in San Bernardino. While body cameras are not yet mandatory in California, their lodged law enforcement agencies last year and found that some of the largest police and sheriff's departments have given body cameras to all their uniform officers. So this is something that gets rolled out increasingly, wider distribution, and there you go. Body camera footage of alleged criminal incidents can be used in evidence in court, of course, because, to the extent that the cameras are recording something that's happening in real time, then, then fine, play the tape. But this is not play the tape of the thing. This is just someone making a report of the thing, which is not the same. Prosecutors, including the State Department of Justice, had urged the court to admit the body camera footage, partially because it related to a suspect who was on probation, which doesn't have anything to do with anything. A person still has a right to confront their accusers, and this woman doesn't want to testify. So, well, either force her to testify, subpoena her ass in court, or, let it go. Take your pick. Statements not made outside court that cannot be verified are called hearsay. There is an exception for spontaneous statements because the idea is that they're more reliable. So maybe this is a hearsay exception, although debatable. But even if it's a hearsay exception, you still have the right to confront the witnesses against you. So hearsay only gets you past part of the problem. So, all right, it's not hearsay anymore. It's a hearsay exception. So fine, but how about the right to confront the witness? In the case that was before the Supreme Court of California, a woman had called 911 reporting that someone was trying to break into the house while she was working as an aide to a person with a disability. Responding officers found damage to the door and a guy at the back of the house. The woman had bruises and scratches on her face and told an officer wearing a body camera that Gray had kicked in the door and assaulted her. Gray was on probation. So, all right, we 911 call. This guy's trying to break into my house. We come to the house. We can't help noticing that there's damage to the front door. We can't help noticing the guy is still there. We can't help noticing bruises and scratches on the face. So, okay, something is wrong. A few days later, however, a woman partially recanted her story, which is commonplace in cases of intimate partner violence, and refused to appear despite the subpoena. Which, you could force her if you want to, arrest her and force her to appear if you want to, but California doesn't want to do that. They don't want to force the woman to appear, which, fair enough. They tried to introduce the body cam footage, but the judge said, no, you can't do it. The criminal case was dismissed, but prosecutors asked the judge to revoke probation, and it was used as part of the probation violation. So the judge said no as to the underlying criminal case, but yes as to evidence that he violated probation, which, is still a thing that, needs to be done. The judge at Gray's prohibition revocation hearing ruled the woman's statement qualified as a spontaneous statement, revoked probation, and orders him to serve an additional 7 years in prison. So, that's fairly consequential. We're not going to charge you with the breaking and entering and the assault unto itself, but we are going to send you back to jail for another 7 years for the crime you were already released on. But this is evidence being used against you, and you have no right to confront. The court actually has a unique ability to see, hear, and the woman. It's not just audio tape. It's not just reiteration of officer in the state. Rather, it's actual video footage of who she is and how she presented at the time. It gives the court ample basis to find defendant in violation of probation. So they're like, oh, okay, as it relates to a probation violation, no muss, no fuss. On appeal, the man said the decision to introduce the body cam footage as testimony violated his rights. State's prosecutors argued that due process rights at probation hearings are flexible. Which, okay, I mean, there is some logic to that. So they're not completely wrong, but still. Probation revocation hearings are not entitled to full array of constitutional rights available to defendants at criminal trials because probationers have been validly convicted of crimes have already been afforded the full rights in the criminal proceedings resulting in their criminal convictions. So yes, the due process nature of a probation revocation is a little different than the underlying criminal trial, but there still are some rights before we send you back to jail for another 7 years. A California appellate court agreed and affirmed the decision to revoke the probation. The case then went to state Supreme Court. Previous probation revocation cases relying solely on paper evidence offer a variety of results. In one 1981 case, the Supreme Court rejected prosecutors' use of a trial court transcript in lieu of witness testimony. Another case affirmed prosecutors' use of hotel and car rental receipts to prove a defendant had broken rules of his probation by traveling out of state. This week, the High Court agreed defendants have the right to due process, including the right to confront their accuser. The Attorney General asserts this particular liability and unique nature of spontaneous statements make them categorically admissible under due process clause without requiring further finding. We reject this categorical approach, and the court sends it back for further analysis. Thus, that brings us to the end of the story about the California body camera not being able to be used against the guy because in this case, the body camera merely recorded a witness's report rather than objective evidence. So it wasn't that the person pointed the police to something that they then wanted to use, which would be totally fine, right? Because, well, now the best evidence is the thing, right? We found the thing. So you can confront that if you want. The witness's report is neither here nor there. We have the thing. But in this case, the witness's report is the thing. So you have the ability to confront that. And so, yeah, that makes sense. And at least for the moment, that brings us to the end of the discussion of this story.